Hi, my name's Steph Douthwaite and I'm a partner at Harrogate Family Law. And together with Sarah Scullion, who is a senior associate at Freeths, we're going to discuss the Northern Resolve model from a lawyer's perspective and how legal advice can weave into that process. Other members of Northern Resolve have recorded other videos which explain what the process involves, and how mediation and arbitration are used together to create flexibility as well as certainty in resolving family law matters. Shall we start then, Sarah, with explaining what we in our experience think are the merits of this generally for our clients?
Yes, thanks, Steph. So just to reiterate there, we do have some other episodes available which will provide a bit more of background information about the process and might make what we're about to discuss make a bit more sense. So please do start there. But in terms of, getting straight into the merits of this process for our clients when we have our solicitors' hats on. So from our perspective, it really brings together the benefits of mediation, which is very much a client-led process. And there's a real focus on having a conciliatory approach, whilst also offering the arbitration element as a sort of background fallback security against the risk of delay or disagreement. So traditionally, where we do have delay or disagreement, one person might find themselves having to apply to court for a timetable to be instigated. But where you have arbitration in place as that backstop, that's no longer necessary. So as lawyers, as part of that process, we are there to help drive well-informed discussions, support clients in their negotiations and in navigating the inevitable legal issues that will arise, as well as sort of, the process requirements. So in terms of the initial stages of where we would assist, there is no hard and fast rule that clients need to have a solicitor to resolve family law issues, but there is a benefit in having one. We offer a unique and perspective, and we build that sort of trusted relationship with our clients. So ultimately, clients can feel confident that they've got a specialist in their corner advising them and supporting their best interests, while also making sure that they're focusing on appropriate practical solutions. Steph, do you have anything to add to that?
Yeah, so to reiterate, we can view the situation from the perspective of our clients' best interests, which is our professional duty to our clients. This doesn't have to mean that we get in the way of a compromise, but we'll provide realistic and honest advice about which aspects of their case may be stronger than others, and we can ensure that time and efforts are focused on the issues that are likely to be relevant and constructive towards the outcome. We can spend time getting to understand confidentially our clients and what outcomes are important to them and the worries that they might be experiencing. And we can advise generally if and why this process will work well for them overall in their circumstances. So, turning then to the mediation aspect, how do we assist there?
Yeah, so with mediation, I think it's important to bear in mind that mediators can't give legal advice sort of to each client. They can provide relevant advice in terms of, the general procedure and how the law is applied, but they can't give specific advice to clients. So that's where we can step in. We can give much more tailored advice than what a mediator can. And this can help discussions lead to outcomes that will then be robust from a legal point of view. So with that, we're there advising in the background before and after mediation meetings, or we can be part of the mediation meetings themselves, which means, we're giving real-time legal advice as part of that meeting, as opposed to, both sides going off and taking their own separate legal advice. I think there can be a real benefit to each of you or one of you having a solicitor there in the moment to advise as discussions are taking place. So the process is led and facilitated by the mediator. So in that sense, the extent of our support is flexible and it can come down to the needs and wants of our client. So that means we can be as involved as little or as much as the client would like. And this is particularly helpful from a cost management perspective because we do appreciate that, people don't want to throw all their money at solicitors. They want to use it towards their future housing needs or whatever it might be. Another point to bear in mind is where other professionals or experts are required to assist on a joint basis. So, for example, you might need a pensions expert. We can help make sure that relevant facts or questions, bearing in mind our client's best interests, are put to those professionals to inform their input, which will then influence the outcome. So, if a full agreement is reached in mediation in respect of finances, for example, the relevant court application to make this legally binding will also need to be drawn up. So at that stage, especially, clients will often need a solicitor to do this effectively. Even if lawyers haven't been required much before that stage, there's a lot of legal drafting. You need to make sure that it's correct. You need to make sure that it's robust and that it's enforceable. So that's a bit of an overview in terms of how we can assist with the mediation aspect. So what happens, Steph, if some or all of the issues aren't resolved in mediation and the parties then have to go on to arbitration?
Yeah, so if there's an issue or all the issues perhaps can't be agreed in mediation, this Northern Resolve process leads clients naturally into arbitration so that a qualified third party can make a binding determination to bring the case to a conclusion. The process requirements of arbitration can be bespoke, which is part of the beauty of that process, but inevitably, the arbitrator will need certain information and evidence to inform their decision. Often these aspects will be similar to what's required in court proceedings, and the arbitrator is going to be applying the laws of England and Wales in the same way that a court judge would. So, our expertise as solicitors in managing evidence gathering and presentation of the client's case will assist in this respect. And given the finality of a decision that's going to be made by an arbitrator, because they make a binding decision, clients may feel that there's going to be most benefit of having a solicitor involved at this stage in the Northern Resolve process. And similarly to how Sarah mentioned, we can help with instructing experts jointly within mediation sessions. If expert evidence is going to be used to inform an arbitrator's decision, the clients might especially want their solicitors to be involved in making sure that this is done effectively from the perspective of their best interests. And also, the arbitrator, where solicitors involved, can communicate directly with any instructed solicitors, and that can be helpful to ensure that the case is going to be ready before they then look at the evidence and make their decision. So, hopefully, that's been helpful in touching on both the mediation aspect and the arbitration aspect. Sarah, do you want to conclude and sort of summarize what we have explored?
Yes. So just to recap, throughout mediation, we provide clients with advice and ultimately, hopefully, reassurance that any agreement is fair, in their best interests, and legally robust and enforceable at the point that it's drawn up. In arbitration, we'll support clients in presenting their case and ensuring the evidence is as strong as possible. And for both processes, we can ensure that expert evidence concentrates on the issues that will support our clients' best interests. And once an agreement is reached, or even, as part of mediation, or even if an arbitrator has had to make the binding decision where there is a divorce and financial settlement, this will need to be made into a court order so that it's legally binding, it's enforceable, and that necessary documentation will have a degree of formality around it. It has to go off to be approved. So the client will need to understand the implications of the specific clauses used in the consent order. Overall, we really hope that this process allows clients to feel like they've approached their family law matters with dignity, and also mutual respect for one another. And that's really a sentiment that's very much integral to the Northern Resolve model. And overall, yes, we hope this has been informative, but please do reach out to us on our LinkedIn page or by email if there is anything else that you would like to learn. Thank you.
Thank you.